Did you know that when you bring a civil lawsuit, specifically a medical malpractice lawsuit in New York, during the time that your case proceeds through the discovery process, did you know that the judge at no time will ever come to the conclusion whether or not you have a valid case? You want to know what this is all about? Come join me on this walk through the neighborhood as I tell you exactly what this is about. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Many people think that when they bring a lawsuit, the judge is automatically going to determine whether or not they have a valid case. They think that sometimes the judge is going to decide during the course of their lawsuit whether or not they are entitled to a verdict in their favor. They think that just because they bring a civil lawsuit for medical malpractice seeking money as a form of compensation, that automatically means that at some point during the litigation process before trial, the judge is going to determine that yes, they are entitled to a verdict in their favor, and that the judge is going to tell the defense how much money this case is worth. Let me tell you why none of those things actually take place. When you bring a lawsuit seeking money as a form of compensation against a careless doctor or careless hospital staff, the defense is trying to determine whether or not you actually have a valid basis for a case. Their first knee-jerk reaction to your lawsuit is to deny all your allegations. Because remember, here's what's going on. You believe that something was done wrong by your doctor or hospital staff, causing you significant harm and injury. In order for you as the injured patient to get into the courthouse door, we as the attorneys have to fully evaluate and investigate your case, and we have to have a medical expert confirm that you do in fact have a valid basis for a case. Okay, so the first knee-jerk reaction that the defense does when they get the allegations, the papers that we have served, that we have delivered to the defense, letting them know about your lawsuit, is, oh no, that's absolutely not true. You don't have a valid case whatsoever. But do they really know? Actually, they don't. So in order to try and understand whether or not you truly have a valid basis for a case, we have to go through what's known as the discovery process. And what is that? Each side gets to discover the facts, the real facts in this case. Each side has an opportunity to question the parties who are involved in this treatment, to learn more information about what occurred, what happened, what they remember happening, and what problems the injured patient has today, and how are these problems different than what they had before. So this is the discovery process. We have to provide the defense with documents that will allow them to go ahead and get copies of your medical records. We have to give them documents confirming and showing that you lost income. We have to give them copies and documents of everything that we are going to use to show that you have a valid basis for a case. During the course of your lawsuit, you might be saying, okay, what does the judge have to do with any of this? Actually, the answer is very little. The judge has very little to do with the discovery process except for two important things. In New York, the judge plays a critical role in making sure that this discovery process moves along at the proper pace. The second thing that the judge will do during the course of your lawsuit is control what happens during the course of this case. Meaning, if there is a dispute with discovery, the defense wants 20 years worth of your medical records, and we say, no, you're only entitled to get 3 years worth of your medical records. Now there's a clear dispute. And if we, the attorneys, cannot resolve that dispute amongst ourselves, now the judge has to intervene and make a decision and make a ruling as to what will happen with regard to discovery. These are everyday things that will occur where the judge or the judge's law clerk will get involved in making discovery rulings to determine, okay, when are you producing your doctor for deposition? When are you going to turn over certain records? When are you going to have the injured patient examined by a doctor? All of these things are part of the discovery process. The judge is never actually going to ask the question, well, do you have a valid basis for a case, and prove it to me? You might be thinking, wait a second, doesn't the judge at any point during the course of your litigation determine whether or not you have a valid basis for a case? The answer is no, he doesn't do that. He knows from the outset that the attorney who brings a lawsuit on your behalf has had a medical expert review the records who now confirms that you have a valid basis for a case. It is not the judge's function to determine throughout the course of your litigation, the discovery process, whether or not you have a valid basis for a case. Your attorney has already gone ahead, determined, and sworn to the court that yes, you have a valid basis for a case. So the court will accept that. The defense disputes each of our allegations and says, no, you don't have a valid basis for a case. So what happens next? What happens is that the judge does not get involved in anything except discovery disputes and scheduling of when all of these things have to take place. And now, after all discovery is finished, now the judge gets involved again. And the judge wants to know, okay, you guys have now finished discovery. Each side knows exactly what happened. You've now assessed the risks of going to trial. Is there a chance that we could try and negotiate and settle this case before it ever gets to trial? Does the judge actually determine whether or not you have a valid basis for a case? Does the judge determine how much your case is worth? The answer in most instances is no. But I'll tell you, here is the next step where the judge might get involved. The defense, after all discovery is finished, could very well turn around and say, Judge, you know what? We don't want to negotiate. We want you to throw out Oginski's client's case because we don't believe that they have a valid basis for a case. And you know what the judge tells them? Go make your motion. That's known as a motion for summary judgment. And a motion is nothing more than a formal written request to the judge asking the judge to take action. Now, the defense attorney has to provide detailed reasons why they believe that we don't have a valid basis for a case. And in medical malpractice cases in New York, the defense will have to hire a medical expert, and the defense attorney will then have to have that expert put in a document known as an affirmation or an affidavit so that they can submit it to the court to support their request to throw out your case. Now, what happens after that? What happens after that is now I have to reply to those papers to explain to the judge in detail why we in fact do believe we have a valid basis for a case. And I have to have my own expert itemize and detail exactly why we have a valid case. And now we have to provide that to the court. The court, the judge, now at this point will definitely get involved. It is precisely the judge's function at this point to decide the issue of whether or not we have a valid basis for a case. Now, one last thing I should tell you. The judge, when deciding this motion, when deciding whether or not we have a valid case, is not actually going to decide whether or not you have a valid case. Now, what does that mean? I've just been telling you for a few minutes that the judge at this point is going to be deciding this issue. The judge will be deciding something that will bear significantly on whether or not you have a valid basis for a case. So let me explain. When the defense turns around and asks the judge to throw your case out, they're saying, Judge, Oginski's client doesn't have a valid case, and here's why. We turn around and say, yes, we do, and here's our expert to explain why in detail. If there are questions of fact, now the judge is going to turn around and say, you have multiple experts, they both disagree. I am not here as the fact finder to decide. I'm not here as the fact finder to determine which of these experts are more believable. That's not my function. The judge's function is to decide issues of law. It is the jury, when the case goes to trial, it is the jury's function to decide who's more believable, who's telling the truth. And only by a jury can they decide who's entitled to a verdict. The judge, on the other hand, is going to evaluate those papers and now make a decision about whether or not there are questions of fact. If there are issues or questions of fact, where now the judge can no longer make a legal decision and a legal ruling because there are questions of fact where you have opposing and competing medical experts, the judge is not going to reach the conclusion that you, in fact, have a valid basis for a case. Instead, he may find that there are questions of fact that cannot be answered and can only be answered by a jury, in which case he's going to tell the defense, I'm sorry, there are questions of fact and they cannot be decided on this motion to throw out this case, so your motion, your request is denied. Why do I share this quick information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases here in New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and have not yet started a lawsuit, but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207. or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.